Health, Education, Labor, and Pensions will please come to order. Senator Murray and I will each have an opening statement. Then we'll introduce our witnesses, and senators will have 5 minutes of questions each. I'm delighted to have the witnesses here. This is an extraordinary group of of individuals with a broad perspective about children in elementary and secondary education, and we welcome your comments on how we implement the new reauthorization of the Elementary and Secondary Education Act. This is our third of 6 hearings to discuss the implementation of the Every Student Succeeds Act, which the President signed in December. It's the second opportunity for this committee to hear from states, school districts, teachers, principals, and others that helped us pass this overwhelmingly bipartisan law and are today working together to implement it in a way that's consistent with congressional intent. I want to focus my remarks on the administration's proposed supplement, not supplant regulation. This is the very first opportunity the administration has to write regulations on our new law, and in my view, they earned an F. The reason for that is that the regulation violates the law as implemented since 1970 and seeks to do it in a way that's specifically prohibited in the new law. In writing the new law last year, Congress debated and ultimately chose to leave unchanged a provision in the law referred to as comparability. That's Section 1605. This provision says school districts have to provide at least comparable services with state and local funding to Title I schools and non-Title I schools, but the law plainly states that school districts shall not include teacher pay when they measure spending for purposes of comparability. That's been the law since 1970. We didn't change it last year. There's an entirely separate provision known as supplement, not supplant, that's intended to keep local school districts from using federal Title I dollars as a replacement for state and local dollars in low-income schools. What the department's proposed supplement, not supplant regulation attempts to do is to change comparability by writing a new regulation governing supplement, not supplant. In other words, their proposal would force school districts to include teacher salaries in how they measure state and local spending, and would require that state and local spending in each Title I school be at least equal to the average spent in non-Title I schools. The effect of this would be to violate the law as implemented since 1970, Section 1605. So the administration may get an A for cleverness, but an F for following the law, in my opinion. The negotiated rulemaking committee couldn't agree on the proposal. At least one member, Tony Evers, a witness here today, said that, quote, congressional intent isn't necessarily being followed here, unquote. Last week, the Nonpartisan Congressional Research Service said the same thing. CRS issued a report that said, quote, the department's interpretation appears to go beyond what would be required under a plain language reading of the statute. CRS found that the proposed supplement, not supplant regulations, quote, appear to directly conflict, unquote, with statutory language that, quote, seems to place clear limits on the department's authority and thus raises significant doubts about the department's legal basis for proposed solutions, for proposed regulations, unquote. Today, I'm looking forward to hearing from witnesses whether what I've been hearing from principals, teachers, and education leaders across the country is true. Here's what I've been hearing: that the department's proposed regulation could turn upside down the funding formulas of almost all the state and local school systems across the country. Most states and local districts allocate K through 12 funding to schools based on staffing ratios. This often results in different amounts going to different schools in the same district because teacher salaries vary from school to school for reasons having nothing to do with the school's participation in Title I. Instead, salaries vary because of teacher experience, merit pay, or the subject or grade level they teach. 2, I've been hearing that the proposed regulation could effectively require wholesale transfers of teachers and the breaking of collective bargaining agreements. Number 3, I've been hearing that school districts won't receive enough funds to comply with the proposed regulation. Number 4, that students could be forced to change schools. Number 5, that the proposed regulation could increase the segregation of low-income and high-income students. And number 6, that it could require state and local school districts to move back to the burdensome practice of detailing every individual cost on which they spend money to provide a basic education program to all students, which is exactly what we were trying to free states and districts from when we passed the law. According to the Council of Great City Schools, the proposed regulation would cost $3.9 billion a year just for their 69 urban school systems to eliminate the differences in spending between schools. What the department has done for the first time is to try to put together the two major provisions of the law that have always been separate. On comparability, which is the first one, members of this committee discussed and debated changing this provision. We discussed it at great length over the last 6 years. Senator Bennett of Colorado, who has lots of experience with this, had one proposal. I had another. We ultimately decided not to make changes in comparability. Instead, we included more transparency in the form of public reporting on the amount districts are spending on each student, including teacher salaries, so that parents and teachers know how much money is being spent and can make their own decisions about what to do rather than the federal government mandating it be used in comparability calculations. Then on the second provision in the law, on supplement not supplant, we addressed this provision and made changes with an effort to simplify the law and not make it more complicated. By no stretch of the imagination did we intend, does any of the language in the law say that supplement not supplant may be used to modify the comparability provision. In fact, we specifically prohibited that. We prohibited expressly the Secretary from requiring local school districts to identify individual costs or services as supplemental. We prohibited the Secretary from prescribing any specific methodology that districts use to distribute state and local funds. And most importantly, we prohibited the Secretary from requiring a state, local school district, or school to equalize spending. The proposed regulation is nothing less than a brazen effort to deliberately ignore a law that passed the Senate 85-15, passed the House 359-64, and was signed by the President. No one has to guess what the law says. As the Congressional Research Service says, we can just read its plain language. And if the administration can't follow language on this, it raises grave questions about what we might expect from future regulations. Senator Murray.